Good morning, everyone. Thank you so much for joining. Just going to give it another minute for folks who are still joining the webinar, and then we'll get started. All right. Good morning, everyone. Thank you so much for joining me today. I am Jessica Vargas. I'm the Chief Marketing and Communications Officer with the Connecticut Paid Leave Authority, and I'm thrilled to be able to share this presentation with you through our partnership with the Better Business Bureau for their Building Better Business webinar series. So just a couple of housekeeping tips before we begin. First of all, this is being recorded and you will receive a link to the recording as well as a copy of the deck after the presentation. Just give us a few days just to edit, edit it slightly and then send it to you. And if you have any questions as I'm going through, if you would please use the Q&A feature. I prefer that over the chat just because sometimes things can get lost in the chat and I want to make sure that I'm able to answer your questions. So with that, I'm going to get started. I'm just going to turn my camera off because sometimes my picture covers up part of the screen, and we will get going. So just a quick overview of our agenda. We will talk about the Connecticut Paid Leave Authority. We're also going to talk about FMLA, or the Family and Medical Leave Act, and how it relates to Connecticut paid leave. As I'm going through, you'll probably hear me say several times to keep in mind that FMLA and Connecticut paid leave are two different laws. However, they are very closely intertwined, and so that's why we do talk about FMLA throughout this presentation. We'll review the qualifying reasons that someone can either take job protected leave under FMLA and or apply for benefits under Connecticut paid leave. And we'll go through the key things you need to know about Connecticut paid leave, as well as how to actually implement it in your workplace. And then we'll do the same for FMLA, the key points you need to know, and then how to implement it. And I'll leave you with some additional resources and of course, answer any questions you may have. So quickly, let me introduce you to the Connecticut Paid Leave Authority. We are a quasi-public agency of the state of Connecticut who oversees the program, and our mission is to provide pathways to accessible paid family and medical leave benefits and to really educate and empower everyone who is touched by the program. That includes employers, administrators, healthcare providers, and of course workers, and offer them helpful tools to understand and navigate this new program. A few key dates, sort of what got us to where we are today. So January 1st of 2021 was when employers were to begin deducting contributions from worker wages. That's done through a payroll deduction of 0.5%. The contributions are then remitted quarterly to the Connecticut Paid Leave Authority through our online portal. There is a 30-day grace period at the end of each quarter. So for example, the next upcoming due date will be April 30th, and that will be for first quarter contributions. And then just a few, about 6 weeks ago on January 1st of 2022, the benefits actually became available for eligible workers who are experiencing qualifying reasons. Now let's talk a little bit about FMLA and how it relates to Connecticut paid leave. You may be familiar with FMLA. There are both federal laws and state of Connecticut laws, and they've both been around since the 1990s. The key point about FMLA is that it provides job protected leave for certain qualifying family and health reasons. However, both laws, federal and state, do state that the leave taken under FMLA is unpaid. So there are some employers who provide income replacement either through, one example might be paid maternity or parental leave, or employers might permit their employees to use any of their accruals, so their sick leave, their vacation leave, or any other PTO, while they're out in order to have income replacement, but that's not a requirement of the law under FMLA. The requirement is the job protected piece, meaning that when someone returns from that leave, they're able to go back to their same job with the same terms and conditions that they had before they went on leave. Now, part of the reason that we're providing information about FMLA, even though, again, it is a separate law from Connecticut paid leave, is that the Connecticut FMLA law changed pretty significantly on January 1st of this year. And I will go through what those changes are a bit later in the presentation. Now, I like to think of FMLA and Connecticut paid leave as sort of the opposite sides of the same coin. So on one side, you have FMLA offering job protection. On the other side, you have Connecticut paid leave, which offers income replacement. So Connecticut paid leave, or CTPL, as you'll often see the acronym, the law itself created a source of income replacement benefits for eligible employees who cannot work for the same reasons as FMLA. But Connecticut paid leave in and of itself does not offer job protection. So that's why the two laws really work together very closely. If you have an employee who's going to be going out on FMLA and they're eligible for job protection, the chances are that that reason is also going to make them eligible potentially for Connecticut paid leave. And we're going to get into what those reasons are. So again, these are going to be the same qualifying reasons for both job protection under FMLA and or income replacement under Connecticut paid leave. There are 6 different reasons. The first is what we call medical leave, and that's leave that an employee would take to receive care for or treatment for their own serious health condition. I will explain what constitutes a serious health condition in a few minutes, but just as a side note, serving as an organ or bone marrow donor is qualified as a serious health condition, and therefore someone can take medical leave for that reason. And pregnancy is also a reason someone can take medical leave. The second type of leave is called bonding leave. Bonding leave is the leave that a worker would take to bond with a new child that has entered their home through birth, adoption, or foster care. Both mothers and fathers may take bonding leave, and it can be taken at any time during the 12 months immediately following the child's birth or placement in the home. In the case of adoption or foster care, bonding leave can also be used to attend to pre-placement activities if needed. The third type of leave is caregiver leave. That's leave that a worker would take to provide care for a family member who's experiencing a serious health condition. And we'll talk about who qualifies as a family member under these laws. The next 2 types of leave are specific to our military. There's military caregiver leave, which is leave that a worker would take to care for a military family member who was injured during federal active duty. And then we have what's called qualifying exigency leave. And this is leave that a worker would take if their spouse, child, or parent is on federal active duty, or if they've been notified of an impending call to federal active duty. So, for example, if you have a worker whose spouse is a military member and that spouse primarily provides childcare for the couple's children, and they're notified that they're going to be deployed, the worker might be eligible to take qualifying exigency leave in order to address the issue of childcare once the spouse is deployed. That could be one example. And then the last type of leave falls under the Family Violence Leave Act. And that is leave that a worker who is the victim of family violence can take for the reasons that you see listed. So seeking medical or psychological care or counseling, obtaining services from a victim services organization, relocating, or participating in court proceedings related to the family violence. Under the Connecticut Family Violence Leave Act, there are up to 12 days of either job protected leave or income replacement benefits available in a calendar year. And I will touch on the length of potential leave for the other types of reasons in just a few minutes. So in going through that, you heard me mention a serious health condition several times. So I want to take a moment to just talk about what does that mean? What constitutes a serious health condition? There is a legal definition in the statute of what is a serious health condition. And in order for something to be considered a serious health condition, it does need to meet one or more of the criteria that I'll review now. So the first is that the condition requires the individual to have an overnight stay in a hospital or another medical care facility. And the second would be that the condition causes incapacity of more than 3 days, and the individual seeks treatment from a healthcare provider within the first 7 days of that incapacity, and they're under continuing treatment of the healthcare provider, such as prescription medication and follow-up visits. The next would be a period of incapacity due to a chronic serious health condition for which the individual sees a healthcare provider at least twice per year. Next would be a permanent or long-term condition causing incapacity for which treatment is no longer effective. Examples of this could be the terminal stages of cancer or Alzheimer's disease. The next would be a condition for which restorative surgery was needed after an accident or another injury, in which if the individual did not have that surgery, they would be incapacitated for more than 3 days. So that is, for example, surgery for a broken bone. And then again, as I mentioned previously, pregnancy is considered a serious health condition, and prenatal appointments are also considered part of that serious health condition. Now, understandably, we get quite a lot of inquiries about Connecticut paid leave and COVID, and whether having COVID is a reason that someone can be eligible for Connecticut paid leave benefits. So part of the reason I just wanted to run through the definition of a serious health condition is it will help to kind of put in context what I'm about to say, which is that simply being exposed to or diagnosed with COVID is not in and of itself necessarily considered a serious health condition under the law. So for example, if someone experiences maybe a more mild case of COVID and they don't go to work for a week, but they also are kind of managing it at home with over-the-counter medication and things like that, that would most likely not be considered a serious health condition because they didn't have one of those things that I just went through. They didn't have an overnight stay in the hospital. They weren't under the continuing care of a medical professional, et cetera. However, if someone did have one of those criteria met, they end up in the hospital or they see their healthcare provider who advises that they need prescription medication and wants them to follow up with multiple appointments, or if having COVID results in or exacerbates a chronic condition that they already have, then those are reasons that they could potentially receive Connecticut paid leave benefits. When I talked about caregiver leave, I mentioned that we would go over what relationships would apply for that, what familial relationships. So one thing to keep in mind is that there is a difference between who can take caregiver leave under federal laws versus under the Connecticut laws. Under the federal FMLA law, an employee can only take caregiver leave to care for a parent, a spouse, a child under the age of 18, or a child over the age of 18 who has a disability. Under the Connecticut laws, meaning both Connecticut FMLA and Connecticut paid leave, the familial relationships for which an employee can take caregiver leave are a parent, a spouse, a child of any age, regardless of disability, a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity. What does that mean, related by affinity? It basically recognizes that families come in a lot of different forms, and there's not always a biological or legal relationship between the people that we consider family. So if the employee can show that they have a significant personal bond with someone that's like one of those family relationships, regardless of whether they have a biological or legal relationship, they could be eligible to take caregiver leave to provide care for that person. A couple examples of what this might look like. One would be an aunt or an uncle who relies on the employee for unpaid care, and the relationship between those two is more like what you would normally see between a parent and a child. That could be considered related by affinity. Another example might be an unmarried couple who live together, they have a home, they have a spouse-like relationship, maybe they have children together, but they're not legally married. So in that case, they would be considered related by affinity. Now you kind of have the background about Connecticut paid leave and about FMLA. So let's get into the specifics of what you need to know about each particular law. First, we'll start with what you need to know about Connecticut paid leave. So first and foremost, you need to know if you're considered a covered employer under Connecticut paid leave. Almost all employers who have one or more people working in Connecticut are covered under the Connecticut paid leave program, and non-unionized employees of the state of Connecticut are also covered. There are some exclusions, and these are primarily exclusions because they're covered by other laws. So excluded employers include the federal government, municipalities, and local or regional boards of ed, unless their unionized employees collectively bargain for participation. Non-public elementary and secondary schools are also excluded, as are railroads, governments of other states, and sovereign nations, which of course here in Connecticut would include the two tribes that run our casinos. Now, a special note for independent contractors and or sole proprietors. These individuals are not required by law to participate in the paid leave program. So if you pay self-employment taxes, then you're not an employee and you're not required by law to participate. However, you can enroll if you would like to do so. If you enroll, you do have to stay in the program for at least 3 years, and you would contribute at the same rate as all other employees, so 0.5% of your self-employment earnings. And if you're a sole proprietor who chooses not to opt in for him or herself, but you do have employees on your payroll, then you must register with Connecticut Paid Leave and remit contributions on behalf of your employees, even if you're not participating for yourself. And lastly, if you receive a W-2, then you are considered an employee. And that's true even if you're an owner or an officer of the company. The second thing to know is what makes a worker eligible for Connecticut Paid Leave. I'm going to preface this by saying that we at the Connecticut Paid Leave Authority are the ones who will look at all this data and make the determination if a worker is in fact eligible. But we do want you to know for your awareness what makes someone eligible. So there's two different criteria. One is a minimum earnings criteria, and that is that the worker must have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. That can come from one or more covered employers in Connecticut. So if you have part-time workers, if they can combine wages from other employers as long as those are also covered employers. And so for illustration purposes, the chart that you see shows the quarters that we're considering for any claims that are being made now. So for the time period between January 1st and March 31st. The quarters that would qualify are fourth quarter of 2020, and then first, second, and third quarter of 2021. So as you can see in our example, this hypothetical worker did earn $23.25 in one of those covered quarters. So they would meet this minimum earnings criteria. The second criteria is that they need to either be employed by in Connecticut by a covered employer, or if they're not employed, they need to have been employed within the 12 weeks immediately preceding their claim for benefits. And of course, as I just mentioned, if they're a sole proprietor, they must have opted in to participate in the program. Again, we at the Paid Leave Authority are the ones who will look at this data and make the eligibility determination. The next important thing to know is what are the benefits like? What kind of benefits can your employees potentially receive? So workers who earn minimum wage receive 95% of their base weekly earnings. For example, if you have someone earning $13 an hour, which is current minimum wage, and they work 40 hours a week, they're earning $520 per week. So they would receive 95% of that, or $494. Workers who earn above minimum wage do have a slightly different benefit calculation that I won't get into because it's a lot of math. It's a bit complicated. But in all cases, the benefits are capped at 60 times the state minimum wage, and that currently is $780 per week. We do have a benefits estimator on our website, which you see a screenshot of down there at the bottom left of the slide. And it's very easy to use. So if you have an employee who's asking you this question, you can direct them there. They would just plug in their pay period, frequency, and their gross earnings, and then they would see an estimation of what they could potentially receive from Connecticut Paid Leave. Now, a worker who's eligible can receive up to 12 weeks of income replacement benefits in a 12-month period. Of course, it's based on the medical necessity of whatever kind of leave they're taking, but the maximum is 12 weeks in a 12-month period. The only exceptions are in the case of family violence leave under the Family Violence Leave Act. Only 12 days of those 12 weeks can be used in connection with family violence leave. And if an employee is experiencing incapacitation during pregnancy, they may be eligible for 2 additional weeks on top of the 12. Many employers do offer paid time off, so we want to take a look at the intersection of benefits and how those things might work together with Connecticut paid leave. Before going through these 4 different scenarios, I do want to make you aware of one of the significant changes to Connecticut FMLA, so the job protected piece of it that also impacts this, which is that previously, before 2022, employers could require their employees to use all of their accrued PTO in order to have income replacement during FMLA leave. So if someone had 4 weeks of accrued PTO and they needed to be out for 4 weeks, the employer could require them to use all 4 of those weeks in order to have income replacement. The change that went into effect on January 1st of this year is that employers can no longer do that. They do have to permit their employees to keep up to 2 weeks of their accrued PTO if they would like to use for other purposes later in the year. So in the example that I just gave, if the worker needs to be out for 4 weeks and they have 4 weeks of accrued PTO, the employee needs to be out for 4 weeks. The employer could require them to use 2 weeks of their leave, of their accrued PTO for the leave, but they would have to be allowed to retain the additional 2 weeks if they would like to do so. So keeping that in mind, let's take a look at our 4 different scenarios. In the first example, the worker has no PTO, or perhaps they only have 2 weeks of accrued PTO and they don't want to use it for their leave. So in that case, the worker could receive the full amount of Connecticut paid leave benefits for the full period of their leave because they're not going to be receiving anything from the employer. In the second scenario, the worker has enough PTO to cover their entire leave. So in that case, the worker would be fully compensated by the employer while they're out. And in that case, they would not receive any Connecticut paid leave benefits. They would still have the allotment of 12 weeks of Connecticut paid leave benefits available if they needed to take leave later on in the year. Those are the 2 pretty straightforward examples. In our third scenario, the worker has available paid time off equal to their regular pay that will cover part of their time out on leave. So in that case, the Connecticut paid leave benefits would start after the worker stopped receiving their PTO benefits from the employer. And then in the last scenario, the worker has PTO that will provide some income replacement, but it will be less than their regular wages while they're out. In that case, the worker would be eligible to receive both the Connecticut paid leave benefits and the employer provided PTO from the beginning of their leave, but the combined amount could not exceed 100% of their normal wages. Now, the implementation of the Connecticut Paid Leave Act, there's 2 parts of it. The first is the contributions, which again started January 1st of 2021. So the worker contributes half of 1% of their FICA wages up to the Social Security contribution limit. That's currently $147,000. So even if a worker earns more than that, they would not contribute on any wages above the $147,000. The employer deducts that 0.5% from the employee wages through payroll deduction and remits it through the Connecticut Paid Leave website through their account quarterly, as we talked about. We at the Connecticut Paid Leave Authority receive and reconcile the contributions, process over and underpayments, and can impose penalties for noncompliance. The Connecticut Department of Labor has a role in this in that they can determine whether or not employers are allowed to take catch-up contributions. So for example, right now through the end of first quarter, so ending on March 31st, the Department of Labor has said that employers can deduct an additional 1% on top of the 0.5% for employers who may have missed contributions last year to make up for that. So for this first quarter of this year, employers can deduct up to 1.5% to catch up. However, starting on April 1st, that would revert back to the 0.5%, and employers cannot take any additional contributions without getting express permission through the Department of Labor. On the claim side, so this process really is primarily on the worker. We tried to make it very turnkey and very little for the employer to do in terms of paperwork. So the worker should notify their employer about their Connecticut paid leave claim. That's not something that we want you to find out from us. That should come from your employee. And then the worker should submit their application in a timely fashion. What that means is 30 days in advance of any planned leaves and as soon as possible for any unplanned or emergency leaves. There are two ways to apply. They can either do it through our online portal at ctpaidleave.org, or they can call AFLAC. AFLAC is our third-party claims administrator, so they can also call AFLAC and submit their application telephonically with the phone number that you see on the screen. AFLAC will let them know what kind of documentation they need to provide based on the type of leave that they're taking. So they will provide that supporting documentation directly to AFLAC. And they are also responsible for updating AFLAC with any absence information and information about other income that they're receiving. One form that the worker will receive as part of their application is what's called an employment verification form. So they'll fill out their personal information, and then they'll provide that to you at the employer. And what you need to do is it's just about 1.5 pages long. Fill out some information about their typical work schedule, their hours, etc., as well as information about whether there's a short-term disability policy that needs to be considered. So you will fill out that portion of the form and return it directly to AFLAC with the information that is included on the form. And for our purposes, that's really the only thing that the Connecticut Paid Leave Authority will ask the employer to do. However, other things to keep in mind is that you should notify your worker about your PTO policies, as well as your short-term disability policy. We're often asked whether Connecticut Paid Leave pays first or short-term disability pays first, and that really is dependent on your policy and how it's written. Many policies are written so that they are the payer of last resort, meaning that any state or employer provided benefits would have to come first, but not all policies are written that way. So it would be helpful to get your policy out and take a look at that. And then of course you would want to refrain from any discrimination or retaliation. At the Connecticut Paid Leave Authority, in conjunction with AFLAC, we will determine if the employee is eligible for benefits. We'll then review their supporting documents. We'll let them know if anything is missing. And once we have a complete file, we will review it and approve or deny their claim as appropriate. Once that claim is approved or denied, we will send a communication to the employer stating the employee's name, whether the claim was approved or denied, and if it was approved, what the start and end dates of the approval are, and what the weekly benefit amount from Connecticut Paid Leave will be. We also calculate and pay the benefits. The benefits are paid on Tuesdays, typically 1 week in arrears, and they're delivered directly to the employee either through a direct deposit to their bank account or a Visa debit card. We monitor the ongoing claims, investigate potential fraud, and can impose penalties as appropriate. If an employee's claim is denied, they have the right to request what's called a reconsideration, where we will essentially look at the entire claim again as though it were a brand new claim. It could have been denied because they were missing a piece of documentation or something like that. So we'll give the opportunity for them to supply anything that perhaps was still missing and look at that again. The Department of Labor will hear appeals related to the denial of claims. So if someone either does not want to request that reconsideration or they do request it and they're again denied, then they have the option to go to the Department of Labor and file an appeal. Now let's talk about what you need to know about FMLA. So again, FMLA is the Family and Medical Leave Act, and that is the law that provides job protection for people taking time away from work for the qualifying reasons that we talked about a little bit earlier. As you heard me mention, there's both a federal and a Connecticut law. So first and foremost, you need to know if your business is covered under FMLA. For federal FMLA purposes, employers who have 50 or more employees within a 75-mile radius are covered. And that does include government entities of any size, including the ones that you see listed on the left side of the screen. Now, under Connecticut FMLA, this is where we're going to get into talking about some of those pretty substantial changes that I said have gone into effect as of January 1st. Connecticut FMLA now applies to almost all employers who have one or more people working in Connecticut. All state of Connecticut employees are covered under FMLA. The entities that are not covered under Connecticut FMLA are the same as those that are not covered under the Connecticut paid leave laws. So that includes the federal government, municipalities, boards of ed, non-public elementary and secondary schools, railroads, governments of other states, and sovereign nations. So this is a pretty substantial change. Before 2022, businesses in Connecticut needed to have 75 or more employees in order to be covered under Connecticut FMLA. Again, that now is 1 or more employees. The eligibility for Connecticut FMLA has also changed. So let's review both federal and Connecticut. To be eligible for federal FMLA, an employee must have been employed by your company for at least 12 months and worked at least 1,250 hours in the 12 months immediately preceding their leave. That has not changed. Connecticut FMLA has changed. Employees are now eligible for job protection under Connecticut FMLA if they've been employed for at least 3 months immediately preceding their leave, and there is no longer any hours worked requirement. So it's important for you to know this information because you as the employer are the one who will make the eligibility determinations for job protection under FMLA. Whereas the Connecticut Paid Leave Authority makes all of the eligibility determinations for Connecticut paid leave benefits, the conversation about job protection is really between the employer and the employee. Let's take a look at how long job protected leave is. Under federal FMLA, there's up to 12 weeks of leave in a 12-month period for all FMLA reasons, with the exception of military caregiver leave, which provides for up to 26 weeks. Connecticut FMLA now very closely mirrors federal FMLA, with up to 12 weeks in a 12-month period for almost all leave reasons. We do also provide up to 26 weeks for military caregiver leave. And there is that additional 2 weeks of either job protection and or Connecticut paid leave benefits for incapacitation during pregnancy. And the Connecticut Family Violence Leave Act provides for up to 12 days in a calendar year. Here's a side-by-side comparison of what Connecticut FMLA was prior to 2022 and what it is now. So you heard me mention previously, only employers with 75 or more employees needed to consider FMLA, Connecticut FMLA that is. Now employers with 1 or more employees need to consider Connecticut FMLA. Previously, job protection was after 12 months and 1,000 hours of employment. It's now after 3 months of employment and there's no hours worked requirement. The timeframes have changed, as we just saw in the previous slide. So prior to this year, there were up to 16 weeks of leave in a 24-month period. That's now 12 weeks of leave in a 12-month period. And as I mentioned a few slides ago, previously the employer could require their employee to use all of their accrued PTO during leave in order to have income replacement. You now must allow your employee to retain up to 2 weeks of their accrued PTO for use later in the year if they would like to do that. If the employee wants to use all of their accrued PTO, that's fine. It's just if they say they want to hold on to 2 weeks, you do have to allow them to do that. Now, what do you have to do to implement FMLA? So here are the responsibilities for FMLA claims. The worker, again, should notify you in a timely fashion, so ideally 30 days before their leave if it's planned. They would submit their application as necessary directly to you, their employer. They would provide you with supporting documentation, and they would comply with your attendance and call-in policies as outlined in your handbook. You as the employer should have an established leave policy, including rules about your PTO usage. What I mean by that is, for example, if you have an employee who's going out to take care of a family member and using FMLA for that, can they use their own sick time or do they have to use only their vacation time? Just one example. Of course, have the FMLA poster in your workplace. You will process FMLA leave requests, monitor an employee's usage to make sure that they don't exceed the time that they've been approved for, manage their return to work, and refrain from discrimination. Connecticut Paid Leave Authority, as I mentioned at the very beginning of our presentation, we do not have any official responsibilities related to Connecticut FMLA, but we do provide this training. As I think you can probably see by now, it's pretty difficult to talk about Connecticut paid leave without talking about FMLA, as they are closely intertwined. Connecticut Department of Labor is the agency that oversees Connecticut FMLA and provides guidance. You can see the web address down there. It's a pretty long one, ct.gov/DOLUI/new FMLA guidance. That is a landing page they have created that has everything you would need to know about the Connecticut FMLA law as they stand now, including forms to provide to your employees, notices of rights and responsibilities, and frequently asked questions. And any questions on the federal FMLA side would be found on the Federal Department of Labor website. What does the process look like for you if a worker comes to you and says that they are going to need time off from work? One thing to keep in mind is that they do not need to say, I need time off for FMLA. If the reason that they tell you seems like it falls under one of those qualifying reasons that we reviewed, then you do need to go through this process to determine if they're eligible for job protection. Again, and I know at this point I'm probably sounding a bit like a broken record, so for that I apologize, but it's really important that you know and that you communicate to your employees that applying for Connecticut paid leave is not the same thing as applying for FMLA and vice versa. So what we want to make sure doesn't happen is that people apply for Connecticut paid leave and therefore think that they also have job protection, because that is not the case. So once the employee comes to you, you will determine if they're eligible for job protection under Connecticut FMLA. And you have 5 days to notify them if they're eligible and provide what's called the Notice of Rights and Responsibilities, which again, you can find on the Connecticut Department of Labor website. So this is not the leave approval. This is just you looking at, are they going out for a qualifying reason? And do they have that 3 months of employment with your company that would qualify them for job protection? Then the worker provides you with the required documentation to support their leave reason. So based on why they're going out on leave, that could be a medical certification, it could be a child's birth certificate, military orders if it's for the qualifying exigency leave. So the worker has 15 calendar days to give you those documents. If they're having a hard time obtaining them and they tell you that, then you should give them a reasonable time extension. Once you have all the documents, you review them, and then you notify them the employee within 5 business days if they are approved for job protection under Connecticut and or federal FMLA. You should also tell them about your requirement for use of PTO and when or how they should call in, as well as whether they'll need to provide a fitness for duty form before returning. And then the worker reports to you when they actually take their leave, and they should say, I'm using my FMLA leave. And the employer will track that usage to ensure that they do not exceed the time that they've been approved for. The reason it's important for the worker to say this is my FMLA leave is that in the case of continuous leave where they're going to be out for a block of continuous time, it's obviously pretty easy to know that that's the reason they're going out. But in the cases of intermittent leave where someone may take time off sporadically, perhaps they have a serious health condition that flares up at times that they can't predict. So maybe they have migraines that obviously they wouldn't be able to say when they're going to be suffering from a migraine so severe that they need to take time off of work. In a case like that, it would be important for them when they do call in to identify that they were taking their FMLA leave at that time. And then when the worker returns, the employer returns them to the job they had before they went on leave. So the same job, the same terms and conditions. You can't take a worker who used to be on the 9 to 5 shift and tell them that you only have a space for them in the overnight shift, for example. So it's the right to get their same job back when they return. And if they were out for their own serious health condition, it's possible they may have some medical restrictions. So you as the employer should consider whether there are any reasonable accommodations that you can make to allow them to perform the essential functions of their job. And that takes us to some other laws to just have in the back of your mind. Laws that provide job protected leave. We talked extensively, of course, about FMLA. There's also workers' compensation for covered on-the-job illnesses or injuries. That provides not only job protection, but also income replacement. And then there are 3 other laws, the Americans with Disabilities Act, the Pregnancy Disabilities Act, both of which apply to businesses with 15 or more employees, and the Connecticut Fair Employment Practices Act, which applies to businesses with 3 or more employees. All of those laws state that leave may be considered a reasonable accommodation, so that's important to keep in mind. I know I have given you a lot of information in a short period of time, so I do want to make you aware of resources where you can find additional detail. On our website, which is ctpaidleave.org, we have some downloadable toolkits that can be really useful. We have an employer toolkit and a human resources toolkit, and those will give you much more detail about all of the topics I just discussed. We also have several forms that you can download and provide to your employees. So we have an employee rights poster, a rack card, a paycheck insert, and a fact sheet. We also do have several hundred frequently asked questions on our website that can be really useful. And if you do have questions and you need to speak to someone at the Connecticut Paid Leave Authority, we do not have a call center, but we do have a contact us portal on our website where you can go in, you can enter your question. And if you would prefer to speak to someone instead of emailing, that's fine. You would just indicate that, and then one of our contact center specialists would reply to you. Typically, we reply within 48 business hours. Again, anything related to the Connecticut FMLA would be found on the Department of Labor website. And with that, we conclude the program, or the presentation, I should say. And I'd be happy to answer any questions you may have. I don't see anything that came into the Q&A yet, but we do have some time left. So if you would like to enter any questions into the Q&A, I would be happy to answer them for you. Just while I'm waiting to see if anyone has anything to put in, I'm just going to put our website in the chat for everyone. And I will put the Department of Labor source as well. Oh, I see a question that came in. Is this retroactive? So Connecticut Paid Leave is not retroactive. So for any leaves that someone would have taken in 2021, they cannot claim any benefits for that. So it's only for things that happened January 1st moving forward. There's another one. I have an employee who is caring for his mother with cancer. He has been employed with us since October. However, he was laid off in November. Does he still qualify as having been employed for 3 months? That's a good question. So that really, Kathy, sounds like more of an FMLA question. So I would advise that you go to the Department of Labor website to find the answer for that. For the Connecticut Paid Leave portion, we would be looking at the minimum earnings, and if it would really depend on, I guess, the answer from Department of Labor as to whether he had met that 3-month of employment requirement. If you are part of a municipality and not eligible and negotiate with the union to be part of CTFMLA, the employees then get the 0.5% deducted from their pay. So if municipality, if the union collectively bargains to be included in the Connecticut Paid Leave program, then all the employees, both union and non-union, would be covered. And in that case, yes, then they would have the 0.5% deducted from their pay. A copy of the webinar emailed to you? Yes, absolutely. We will send you a copy both of the recording and of the presentation. Just give us a couple of days to get that out. It can take a while to download the Zoom recording and get it out. Margaret, thank you for your comment. I'm glad you found the presentation helpful. Would an employee needing surgery and a 12-week recovery period be eligible for Connecticut Paid Leave? So Lisa, the answer to that is from the Connecticut Paid Leave side, they would need to meet the minimum earnings and the employment criteria. So they would need to have been employed for at least 12 weeks immediately preceding their leave, and they would have needed to have earned the 2325 in one of the 4 of the 5 most recently completed quarters. Can you explain the 12 weeks of employment to be eligible if the entity is not eligible? I'm not if that's from an anonymous attendee. If you could just maybe elaborate a little bit on that. I'm not sure I understand. I'm not sure I understand what that question is. I just want to make sure I answer it properly. Thank you so much for your comments. I'm really glad you found the presentation helpful. The 12 weeks were part of the initial presentation. Okay, so this is going back to the question about 12 weeks of employment. So let me say this and see if it answers the question. So for an employee to be eligible for paid leave, there's a couple of things. So first is they have to work for a covered employer. The second is that they need to have been employed for at least 12 weeks immediately prior to their leave. If they're not currently employed with a covered employer, so if they're unemployed, for example, if they were employed by a covered employer within the 12 weeks preceding their leave, then that would also count as them sort of checking the box for that eligibility requirement if they also met the minimum earnings criteria. I'm not sure if that answers your question, but I hope that it does. Okay. I don't see any other open questions in the Q&A. Again, thank you so much for inviting us to be part of this. Thank you, Jackie. We're really, really pleased to be able to share this information. And if you do have any additional questions, again, our website has so much information, but please do use the Contact Us portal if you have any additional questions. Our team is very knowledgeable and very responsive, and we will get back to you. And then last thing I'll just leave you with, we do have a dedicated page on our website specifically for small businesses. So if you go to our website, up in the navigation bar, there's a drop down that says the process, and then there's a tab for small businesses. And so that is a really helpful page that has a little bit more specific information for smaller businesses who may have 75 or fewer employees. If you were going to donate a kidney, would it cover your pay at 95%? So Jackie Ann, the benefit calculation is dependent on earnings. The 95% is for someone who's earning minimum wage. Someone who earns above minimum wage, there's a different calculation. And I'll explain it, although it's very complicated. I'll preface it by saying that. So someone who earns above minimum wage, it's 95% of 40 times the minimum wage, which is $494 per week, plus the difference between what the person actually earns and that 494. So it's basically the 95% of 40 times minimum wage plus a bit of an additional amount. And so that's why we don't really go through the explanation, because it's complicated. It's, even when it's written out on a slide, it's sort of hard to comprehend. But I would say the benefits estimator would be the best place to go, because you can type in your weekly, quarterly, or annual earnings, and you will get an estimate based on what you earn. The system will put it into the formula and spit back out what you could expect to receive. All right, I see no other open questions, so we'll give you back about 13 minutes to your morning. Oh, okay, you're welcome, Jackie. All right, thank you again. Thank you for having me, and please do reach out to us with any additional questions at all. Have a great morning, everyone.